You think you know what a will does? Think again. I'm a licensed estate planning attorney in North Carolina and South Carolina, and today I'm breaking down what most people get wrong about wills. If you think a will helps you avoid probate or guarantees your family won't fight, this video is for you. My name is JP Rankin. I'm a licensed estate planning attorney in North Carolina, South Carolina, and California. I've helped hundreds of families avoid probate, create generational wealth, and ensure that their family's legacy lives on for generations to come. If you're in North Carolina, South Carolina, or California, hit subscribe and let's get really into how wills work. What a will actually does. A will is a legal document that says who gets what and in what amount when you die. It names your beneficiaries, that means who's getting the assets, your executor, the person in charge, and sometimes a guardian for minor children. It only kicks in when you die. This is an important note, as often people really overlook the significance. It does nothing during your lifetime. The will must go through probate, which is a public court supervised process. That means everyone knows what you have and who is set to receive those things when the court eventually validates the will. What a will does not do: it does not avoid probate. It does not automatically transfer ownership. This is a big one for people to wrap their heads around. It is most definitely not like what we see in the movies. There isn't some fancy attorney like me sitting in a giant conference room where all the kids are gathered, and then he says, "Guess what, Nicole? You get the house and here are the keys." That's just not how it works. It doesn't control assets with beneficiary designations like insurance or retirement accounts. It does not override joint ownership with rights of survivorship. In both North Carolina and South Carolina, even with a will, probate can take months or even years. So the risks of relying on just a will: there are going to be delays. Your executor can't act until the court actually authorizes them. There are going to be a number of costs, so probate fees, executor commissions, and even some legal fees. There are going to be family disputes, more likely than not, because wills can be challenged. They are being audited in a court of public opinion, and that means the probate court judge has to listen to what anyone has to say, whether they're family or not. So if Aunt Linda says, "I was supposed to get the fancy china," the judge might have to listen to that, and whether he decides with her or not, it's going to take up some extra time. It's public record. Your assets and your heirs become part of the public record, so everyone knows who they are and what they got. North Carolina and South Carolina have elective share laws. That means your spouse may still get a portion even if you leave them out of the will intentionally. There are some situations when a will makes sense. So let's say you have simple assets and you don't mind your loved ones having to endure probate after you've passed away. You've got minor kids and you need to name a permanent guardian. Very important time to use a will. You haven't gotten around to a trust yet, but at least want something in writing. Now, I hear this one a lot, and although it's technically correct, oftentimes the basic will you created from years ago because you weren't ready for a trust at that time, it's going to have to be invalidated, and what's known as a pour-over will is going to get drawn up in its place because it works in conjunction with the revocable living trust, and it works as a fail-safe in case you forget to properly fund one of your assets or something comes down from an inheritance you didn't know about. Or what happens more likely than not is you've got an old 401k from an old employer that you didn't know about or forgot about, and now your executor has to deal with it and put it into the trust. So there are some better alternatives. Revocable living trust, we're going to explain that in another video at length, so go ahead and check that one out if you're curious. Payable on death accounts, so that is a bank account. They call them payment on death at the banks instead of having a beneficiary or a transfer on death account. Joint ownership with rights of survivorship, so most people that are married that have purchased their home while they were married, they have joint ownership. That means when one of the parties dies, the surviving spouse instantly owns the home, and there is no document, including a will, that will override that. But you still need a will as a backup, just in case something falls through the cracks, and that's what's known as a pour-over will to work with your revocable living trust. So don't leave your legacy to chance. If you're in North Carolina or South Carolina, schedule a free consultation with me at Rankin Law Firm so we can discuss what it is and how important this is to your family. Also, hit like, subscribe, and comment below what surprised you most about how wills really work.